This law case presentation is on whaling in the Antarctic, Australia versus Japan, with New Zealand intervening, by Amanda Tilley at St. Petersburg College for the class Legal Ethical Issues in Veterinary Technology. In this presentation, we'll start with basic definitions that will be used throughout, then go into what whaling is, and a brief history of the International Whaling Commission as well as whaling in Australia and Japan. Then we'll go over a general synopsis of the case, detail out Australia and New Zealand's argument in the case, as well as Japan's argument in defense, then ruling and judgment by the court system, and then my reflection of the case at the end. IWC stands for International Whaling Commission. A moratorium is a suspension or ending. JARPA 2 is the Japanese whale research program under special permit in the Antarctic in its second phase. ICRW stands for International Convention for the Regulation of Whaling. Article 8 is a portion of the ICRW that allows for killing of whales for scientific purposes. And then ICJ stands for the International Court of Justice. So what is whaling? Whaling is actually defined as the hunting of whales for meat or oil. Norway, Iceland, and Japan began whaling an estimated 4,000 years ago. And in that time, all parts of the whale were used. The meat was used for food. Blubber was melted down into oil for lamps. The bone was used for corsets and hoop skirts, and also for tools and implements. And lastly, the baleen was used in baskets. And baleen is actually the plates that hang from the upper jaw of the whale for certain whale species that filter water and food. They act like teeth. The IWC was founded in 1946 with the intention of preventing whale extinctions by regulating whaling. A moratorium was placed on commercial whaling by the IWC in 1986, and at that time they instituted special permitting known as scientific research permitting. They also established sanctuaries in the Indian Ocean in 1979 and in the surrounding oceans of the Antarctic in 1994. Australia began whaling in the late 18th century. Whaling and whale product exports were the first primary industry of Australia, and in the 19th century, productivity increased drastically due to upgraded technologies such as harpoon guns and steamboat engines. This increase in productivity led to the decrease of whale population, and over time, as the populations fell drastically, it caused the collapse of the whaling industry in Australia. Commercial whaling actually ended in 1978, and in 1979, Australia established an anti-whaling policy and began focusing on the IWC and the international conservation of whaling. And at this time, they're currently active in multiple committees within the IWC. As I stated before, Japan actually practiced small-scale whaling for centuries, but commercial whaling didn't really become popular until the late 17th century. They joined the IWC in 1951, but formally opposed the commercial whaling suspension the IWC put into effect in 1982. They, though, retracted that objection in 1985 due to political pressures from multiple countries, including the US. After that, they acquired special permitting for scientific research whaling in 1988. Under the scientific research whaling, they harvested an average of 1,800 whales annually, and the whales were harvested and processed at facilities with samples sent out to laboratories, and those included eyes, ovaries, and stomach contents. In 2005, Japan created JARPA 2, which was the second phase of JARPA, and in that they outlined a plan of culling over 1,000 whales annually for 16 years. So now that we have a little bit of historical background on both of these countries, I'll do a brief case overview before getting into the details on the next couple of slides. So basically, Japan's being accused of exploiting a loophole in the commercial whaling moratorium, which includes abusing special permitting, breaching the ICRW's Article 8, and whaling in the Southern Ocean Sanctuary, which is the sanctuary surrounding the Antarctic. They're also in question of whether or not the special permitting obtained by Japan qualifies under Article 8 and whether or not the JARPA 2 is properly permitted for their claim of scientific research. So this case began when Australia filed an application to the ICJ on May 31st of 2010 with the statement of the JARPA 2 breaching obligations assumed by Japan under the ICRW, and that it breached additional international obligations for the preservation for marine mammals and the marine environment. Some of these included the zero catch limit for commercial whaling, no commercial whaling of fin whales in the Southern Ocean Sanctuary, and that they could not use factory ships or whale catchers attached to factory ships in their research expeditions. It was also claimed that JARPA 2 was not used for scientific research purposes, as outlined in Article 8 of the ICRW. Initially, Japan argued that the ICJ had no jurisdiction over the claims in Australia's application regarding the JARPA 2, and that New Zealand's application to intervene alongside Australia had lapsed. They also stated that the area used by the JARPA 2 for its scientific research whaling was close to the Southern Ocean Sanctuary but not directly related to it, and was considering that area high seas and not actual sanctuary property. They also maintained that JARPA 2 is an 18-year scientific research program and is exempt from the constraints of the Article 8 of the ICRW. After hearing testimony and statements from Australia, New Zealand, and Japan, the court ruled as follows. They found that they did have the jurisdiction to review and make judgment on the application from Australia that they filed on May 31st, 2010, and that the intervention of New Zealand had not lapsed. They found that JARPA 2's design and implementation were not reasonable in relation to the program's stated special permitting objectives. The court felt that the scientific data that the JARPA 2 had collected was too little in comparison to the time spent on that scientific research. They also felt that the JARPA 2 program had isolated themselves and their scientific findings from other countries and other organizations. And lastly, they did feel that JARPA was in violation of multiple areas of the ICRW with regard to the killing, taking, and treating of whales in the Southern Ocean Sanctuary. While there may not be clearly drawn lines of the sanctuary, the court felt that the JARPA 2 was well within the protected areas of the sanctuary and that they knew they were. The final judgment of the court was that Japan must revoke all permits, licenses, and authorizations in relation to JARPA 2, and that they were not allowed to grant any future permits under Article 8 for the JARPA 2. The ICJ also found that it understands that members of the International Committee have divergent views on policies towards whales and whaling that are not for the court to decide or settle. And they also decided that it is not for the ICJ to decide the definition of the term scientific research. As I reflect back on this case, obviously the judgment and ruling is the best case scenario for this situation, for the whales and for the sanctuary and the IWC, as well as Australia and New Zealand as countries. It's going to be significant as far as future rulings with environmental protection situations and conservation situations that go to court. And I hope that the judgment on this case helps move them forward in those cases in the future. The only side note I'd like to make as well on this is that I did find in my research of this case that just a couple months ago, in July of 2019, that Japan actually completely pulled themselves out of the IWC. I would imagine that it would be something along the lines of they're hoping that by not being a part of the commission, that they don't have to abide by the rules and regulations that the commission puts forth. But other than that, like I said, I think this case pretty much went as good as it could have.